welcome to the Priggya Arora Show, where we discuss law and entrepreneurship with people who have been there and done that. My name is Priggya Arora, founder of PA Legal, an intellectual property law firm in India, and our guest for today is very inspiring and famous Mr. Bastian Best. So let us directly dive into a conversation with him. So welcome, Bastian. Thank you for being here.
Hello, Priggya. Thanks for having me. Thanks for the invitation. Hello, everyone. I'm looking forward to our conversation.
Great. So let us begin by, can you tell us your life story and why did you choose a legal career?
My life story. Wow, that's kind of a big question right in the beginning. So let's see. Well, so I would say, I didn't really choose law specifically because, I'm just like you, I'm a patent attorney, and at least in my jurisdiction in Germany and in Europe, we patent attorneys, we are not lawyers. We didn't study law in the classic sense, but we are technical guys at heart and then do an additional education to become patent attorneys. So my passion was always computer stuff. I've been a computer nerd all my life, basically. Got my first computer when I was, I think, 13 years maybe. No internet back in the days at that time, hardly imaginable today. But then I immediately started tweaking, the operating system so that I can run the newest games. And memory was quite an issue back then. And started teaching myself programming with books from the library, purely without the internet. So it was pretty clear to me that I want to do something with IT, computers, programming. So I went to study computer science. Was the only logical choice for me. And after that, after my studies, I started working in the automotive industry first in the development of driver assistance systems, so the electronic helper systems in the cars. And I was fascinated what you can do with software, right? Also on a tangible carrier like the car. In real life scenarios then with this kind of embedded software. But at the same time, I figured out that I was fascinated by technology and by innovation and by learning about new cool things. But on the other hand, I was not so much of a tinkerer myself. And I was not the perfect one to come up with the inventions. That's what I figured out. And then I became aware of the profession of a patent attorney. And I thought, well, this could be really it, because then I would be right at the interface between, I don't have to invent, I get the inventions, and then I have to kind of, sell them to the patent office, to other companies and things like that, to the courts. And then I took the leap and escaped from the automotive industry, from my development career path, and started my education as a patent attorney, and that's what I've done ever since. And never regretted it.
Great, absolutely awesome. So it's like how all the dots connect, and we choose our passion and work in a stream where we can have a mix of everything. So thank you so much for sharing that.
Absolutely. That's one special thing about being a patent attorney that's so intriguing to me, that I'm still in my field of competence. I only work on software related cases and digital inventions. So I really can use my academic knowledge as a computer scientist. On the other hand, I'm getting into touch every day with all sorts of, let's say, application domains of the software inventions. For example, for AI related inventions, artificial intelligence. That's very interesting for me as a computer scientist, but the inventions are always in a specific domain, and the domain is always different and always outside of my circle of competence, which makes it very, very interesting for me, because I learn something new every day, basically. But at the same time, I can build on my knowledge. So that's a great combination for me.
Yeah, great. So being a patent attorney is always about learning new things, new inventions, and what's happening around the world in terms of whatever technology is being developed. So I think it's pretty interesting to be a patent attorney.
Absolutely.
Yeah. So, Bastian, what are the best and worst part of your job? Because you have been in this industry since a decade, and what do you think, according to you, are the best part of your job and the probably not so good part of your job?
Let's see. So the best part, one of the best things I already mentioned, it's this mix of being a specialist in your domain, but still being in touch with all sorts of surrounding technologies. So, for example, again, speaking of the AI patent applications I'm working on for my clients, right now I'm dealing with inventions. Let me see. In medical technology, for example, in computer security, cryptography. Then we have industrial automation, so companies controlling their production plants with AI and making things like predictive maintenance. So it's always really diverse for me. So that's one of the biggest advantages, I would say, topic-wise, for the job. And for the type of job, I would say what really intrigues me also is the freedom to work from anywhere. I mean, yeah, that's really, I think being a patent attorney is one of the rare jobs where this is really possible to do it, because I mean, yeah, it's in that sense, it's kind of a classic consultant job. So all I need for doing my job is basically my knowledge, my experience, and a computer with internet access, and that's all I need. So I can work where I want, when I want, and that gives a great degree of freedom. That's what I really love about the job. The worst parts of the job, let me see. Of course, I mean, not everything is great always. I think the most disappointing, on the one hand, there is really not much negative things, I would say, because it's just I just love it. What's really annoying is, of course, when I think that's the most annoying situation when, I mean, for example, drafting a patent application and prosecuting it through the patent office takes a lot of time and effort, and you really think it through with the inventors and the patent managers from your client's company. So you put a lot of passion in there, and then sometimes you get a rejection from the patent office, although you really disagree. Sometimes it's okay. If the patent examiner found prior art, which is close, then okay. But sometimes, a lot of times in the software field especially, things are really open to interpretation. And sometimes I fundamentally disagree with what the patent office has done, which is not a bad thing in itself. But the bad thing is then, if in such a situation I would really love to fight it through on appeal and take it to the next instance and really have it clarified by the higher jurisdiction then. But sometimes, of course, the client says, no, this invention is from a business perspective not interesting enough to spend the budget, so we just let this case go abandoned. And this is really annoying for me, because I really would have loved to have it sorted out in the end.
Yeah, I know. And, being a patent attorney myself, I also work in computer and digital technology patents, and I'm an electrical engineer by qualification. So I resonate with this so much, because in India also the situation is same, that, and I think throughout the globe the situation regarding software patents is the same. Like, we do not have a straightforward answer that something whether is patentable or not, and it gives a playing field to attorneys as well and to the examiners as well, that we can argue from our point and they can argue from their point. And it sometimes becomes very disappointing that when we are really excited with the technology and examiner is still not agreeing to us.
Exactly. Yeah, that's exactly the point. Yeah, especially in the digital and software based technologies. Here in Europe, the question is always whether the effect, the outcome of the software, whether this solves a technical problem. And then the question is always, is it now a technical problem or is it a non-technical problem which is solved here? And of course, there is no definition of where the borderline is, but it's in the end, it's really a kind of a political decision where you draw the line, at least in the border cases. And yeah, things can get disappointing there, but also at the same time, this makes it so exciting. Yeah. That you can still, in the European system, you can still, with good arguments and making a good case, you can still participate in, let's say, advancing the legal approach, the case law. Yeah, but it takes time, and that's oftentimes disappointing for the clients because, of course, it takes a lot of money to take the cases through all the instances.
So, Bastian, a question just popped into my mind that how do you deal with clients? Do you tell them beforehand that it is somewhere on the borderline, we may or may not get a patent on it, and you have to be okay with it when we do the prosecution? Because it's only after 3 or 4 years we come to know whether we will get a grant or not. And for this 3-4 years, sometimes the clients, they get very agitated. So how do you deal with that?
Yeah, important aspect, of course. Yeah, so I guess this depends a little bit on the type of client. So the clients I work for from large industry corporations or companies who typically have their own patent department in-house. Of course, they know the game, they know the system, and they are most of the time perfectly aware that there are more difficult cases and less difficult cases, or less reliable technologies in terms of patentability. So they are perfectly aware of that, and they take it as it is, right? They have they build their portfolios, and they are aware that some patent applications will not make it and others will make it. So that's fine. And then it is especially important, on the other hand, to talk about these issues with, for example, startup clients who do the whole patenting process for the first time. So they have no idea what to expect. So here it is really important to really explain to them and really teach them how the system works and where the risks are, really upfront. Because as you say, a patent application examination procedure takes like something between 2 and 4 years in Europe, I would say. And yeah, it's really disappointing for them when they start with the wrong premise, so to say.
Yeah, absolutely. So now coming to, something about IP management. So we discussed about IP protection stuff, and I know you have recently started working in the field of IP management too. So can you share something about how that works and what are the skills required for doing the management part of intellectual property?
That's IP management. That's actually one of the most exciting projects I'm in right now. So I was starting out as a classic patent attorney, and as a patent attorney, typically you consider yourself a legal advisor, right, outside of the client's company, of course. And so you most of the time you consider yourself only in charge of handling the patent law related questions. So the client comes to you with an invention report, and then you can estimate the chances of patentability, whether you can get it through at the patent office. And what you also can do is, of course, you can estimate the chances and work on drafting the patent application so that it's enforceable later on. But all these are legal aspects, I would say, patent law related questions. And that's it for many patent attorneys. That's their job, and they are fine with that. And as soon as the client starts asking, okay, now I see from your reports, from your estimations, I see the chances of getting a patent or of being able to enforce that patent against the right competitors, but should I file the patent for what's the business case, right? So this is a whole different question. This is not a legal question, but it's really a business question of whether it makes sense, whether, yeah, the budget you have to put in is justified to have a business-related positive outcome. And that's where IP management comes into play, at least if you understand the term as I do, not in the sense of managing protective rights or managing the work with external law firms, but IP management for me really comes down to the question, where's the business case for patents? When does it make sense, and which patents should you file? I mean, if you have a corporation of a considerable size, and if you have a good incentive system, your developers will come up with all sorts of innovations, right? And the question then comes up, you cannot patent all of them because of budget constraints. So which ones do you file patents for? And all of these are more business related and highly strategic questions. So that's what this umbrella term IP management for me encompasses. And I have to say, I'm learning in this field. I'm not an expert at all yet. I'm really a student of IP management myself, and have the pleasure to be working with some really smart people in the field, in the European IP management scene. And there is this association, the International Institute for IP Management, I3PM, which existed for a long time, but which has now got a new board. And I'm happy to be a part of that board. And this year we have big plans for modernizing this association and for bringing great benefits to its members.
Awesome. And thank you for explaining the difference so beautifully well, because, I have been patent attorney since about 5 years now, and it's very difficult to explain the client that legal side of something is very different from the business and strategic side of it. And as a patent attorney, they expect that we would be knowing the strategic side and the business side, and it's implied that we'll be knowing that. But sometimes it's for us also, it's a learning experience. We have to learn about their business. We have to learn about the balance sheet and things like that to forecast what kind of IP should be filed and what should not be filed. So thank you so much for explaining that. So now now let us switch gears and discuss something about social media. I think that would be one of your favorite topics, because I've been following your channel and I've been a learner myself through your videos. So when did you start getting into social media, and when did you get the idea that you'll simplify patents so that people can experience what actually goes into drafting of patents and things like that?
Yeah, you're hitting the nail on the head with social media, because that's really one of the big pillars of my mission to really help businesses make sense of digital patents, and I do that by spreading, by sharing tons of free stuff online and on social media. How did I get into social media? Well, so originally, I think it started out of me just being a computer nerd, really. So I was always interested in, back in the days when I started having the computer. As I said, there was no internet, but then when the internet came up, and then when slowly at some point in time, things like Facebook at that time was the first really social media platform you would really use, at least in my community. That's when I was fascinated with the idea that you can really put something into the internet. Before that, the internet was just like a library. You could find information there, but it was a one-way street. And then I suddenly realized, well, you can put in stuff there and people will read it probably. So that was intriguing to me. And then I started playing around with, I set up a little blog when I was doing my education to become a patent attorney. to kind of document my journey a little bit, and people picked up on it and read it. It's not online today anymore, and at some time I lost the files, unfortunately. So this first kind of blog doesn't exist anymore. But then I was really hooked on this aspect of being able to share things I consider worth sharing with really a potentially global audience. That's was really fascinating to me. That's why I got into the social media. And then I actually went to my the firm I was working at the time here in Munich, in my hometown. I went to the management and said, well, shouldn't we put up a Facebook profile page for our firm? And then things started to become more marketing like, you know. So then I was using social media more as a marketing channel for the firm and helped the firm build up the Facebook presence. And then we got on Twitter and what was on vogue then. And then, but more recently, I would say for the last 5 or 6 years, I would say, I really returned to this idea of that social media is really less about media, but more about social. I would say it's really about building community, exchanging views. It's not about advertising to an anonymous audience in a one-way unidirectional manner, but it's really about the dialogue. And it's really, in the end, it's really about networking. Okay. Building a network of like-minded people, exchanging opinions, exchanging views, and really spreading knowledge. So, and that's what I do today, and I try to do that on a large scale. Yeah, because it brings so much return. On the one hand, I mean, spreading my own knowledge forces me to really articulate myself clearly. I'm not always managing that, but it forces me to try to do that. And on the other hand, I get so much feedback in return, which is just great.
Wow, awesome. So, Bastian, how about, people share a lot of knowledge in terms of what is intellectual property, what is patent, and how they move forward. But how did you get idea that you'll probably dissect the patent applications and show it to the public, that what we do on a daily basis? Or is there a certain process that you follow, journal watch, or what are the interesting patents, find out them, and then do your dissection and in terms of in front of public? Or how is your process?
I think so. From my point of view, this was really a mind shift for me. So as I said, when I started out with producing content on social media, I kind of fell in this classic trap, I would say, of not really knowing what my audience would like to see, and just guessing and asking myself every week, basically, well, what should I post next week? And then coming up with something caught and something didn't attract many people. So I think that's a classic mistake many people make. And then in the end, I realized that it's really about helping your audience. So first you have to really know who you want to talk to on social media, and then you really have to know what can help those people. And I mean, if you realize that, it's really obvious to just ask the people you want to serve, what is the things you are struggling with, what are your big problems, and then they will tell you. And actually, this idea of dissecting actual European software patents and looking how they are drafted and whether there is something to improve or not, that idea, I do that on YouTube, in my YouTube videos. It's called the Software Patent Review. And the idea really came because people just keep asking me all the time in the software field, wow, is software patentable? What can we patent? We are now developing this and that. Is this really patentable? And so at some point I thought to myself, well, why not just provide examples of things that are granted patents on? And then that was when the idea was born, to just look through existing patents recently granted at the European Patent Office and just discuss those. And the process is really simple. So some of the things I discuss are really patents that are mentioned to me by one of my clients when they say, oh, our competitor or this and that company has a new patent, we found it, and can you tell us what's in there, what is it all about? Then I use those, or I regularly look through the register. Of course, I mean, every patent is published, and I just look up in the register which patents have been recently granted at the European Patent Office in my field, software and digital inventions. And then I scan through them and I discuss the interesting ones.
Awesome, awesome. I like the idea that if you want to make content, you should just ask your audience, what do you want? What questions do you have? And similarly for dissecting patents, like just know your audience well so that you'll be able to get into the right approach.
Yeah. Absolutely. I think it's so simple, but that's really what really many people, I think, which are active on social media really don't do. It's the realization that it's not about you, the producer, so to say, the creator, but it's always about the audience and how you can serve and help the audience.
Correct. Awesome. Love the idea of it's always about the audience and how you can serve your audience. So whenever you produce, I'll just give it as a takeaway to the audience that whenever you want to develop content or you want to build content, keep audience in mind and have a focus on audience, that what do they really want, what do they really want, and you'll get to what kind of content will work for you.
Exactly.
Yeah. So, Bastian, to conclude, can you share some key takeaways to young legal professionals who want to enter into the field, probably start their own law firms or do something in the field of legal entrepreneurship?
Some takeaways for young legal professionals. Yeah. Let's see. What can I say? I would say maybe two pieces of advice if I am allowed to give advice here. So on the one hand, I mean, what I do now today is I've half a year ago I started my own little patent law firm, and my business model is really a hyper niche specialist law firm, right? I'm only doing patents, no designs, no trademarks, no copyrights, just patents, and only for software and digital inventions. So this is really the hyper specialist route, which I took. And I think I can recommend that to everyone, because the more specialized you get, the less competition you have, and yeah, you automatically attract the right clients, which perfectly match to your skills. I think it's great, but I think in the beginning it's probably not the way to do, because when you are young and starting out, you probably don't know yet what your skills really are worth and where really your passion lies. So in the beginning, I would recommend really to be a generalist, to really be broad and to try out different things. And in the legal profession, in the patent profession, in the IP profession, you can do that. You can do trademarks, designs, as I said. You can get your education maybe in a litigation-heavy firm. So you see a lot of court cases, things like that. So that's my one piece of advice, maybe to start out broad and only then at some later point in time narrow down. And the other piece of advice would be, well, this kind of ties back to my urge to spread my knowledge on social media. Maybe the advice would be really to do good work and to let people know about it, because you can't, it doesn't make sense to do just one of that. You know, I mean, you have to do good work, of course, but if no one knows, it's worth nothing. And the opposite is also true. If you tell the world what you do, everyone knows it, but if your work is crap, it doesn't help anyone. So you really have to do both. You have to do good work and you have to let people know about it.
Correct, absolutely awesome. So I'll reiterate what Bastian just said. So he said, start out broad, experiment and explore what do you love, and then probably pick up a field and a niche for yourself, and do good work and let people know about that, about it, that you are doing good work. And whenever you mix all these elements together, I'm sure clients will come to you and you'll not have to go to clients to take work. So clients will automatically come to you if you're a specialist in one field and you're letting people know that you're doing good work.
Exactly. Yeah. Thanks. Great summary. Yeah, exactly.
Thank you so much, Bastian, for being on the show and giving your time. I think time is the most important thing which people can give to each other. So thank you so much for giving me your time and giving our audience your time.
Thank you very much, Priggya. Thank you for having me. This was great fun.
Hey there. Thank you for attending today's session. If you enjoyed our conversation, do follow our channel and consider sharing it with a friend. My name is Priggya Arora, daughter of inspiring parents, alumna of IIT Kharagpur, engineer turned lawyer and entrepreneur, and now founder of PL Legal, where we help creators and innovators protect their intellectual property. Thank you.